Morning, judges.
Good morning.
My name is Joe Brandon. I'm a member of the Rutherford County Bar. I'd like to reserve 5 minutes, please.
All right.
In this particular case, there is a tremendous need for uniformity of decision under the law with respect to two different issues. First deals with the social media. The extent of the social media friending and connections a judge is allowed to have in a particular case and still be subject to trying that case. The second issue deals with the perilous practice of juror questions. It's real easy in these cases when you read appellate opinions for the courts to say that's harmless error. Sure, there's error, but it's harmless. You look at the overall facts of the case. But what we would submit is, imagine a situation where somebody goes to trial and a judge says, we're not even going to give you a jury. We're going to try this case just with a judge. All the proof comes in, all the evidence is presented just like in a jury trial, and then a conclusion is reached. Well, you wouldn't dare say, well, that's okay because look at the evidence, when in fact you had a jury waived in that particular case. I use that example as the jury was not waived in this case, but there are times when something runs so directly in contradiction of the Constitution, it leaves no choice but to call plain error and result in a new trial. Now, when you look at whether error is constitutional or non-constitutional, and I put stuff in my brief, I would also just verbally incorporate my brief into my argument today. You all read, y'all have read this, and there's no point in me going through this as the standard. We argue that this is a constitutional error. Now, with respect to the social media, Facebook, and a judge, in this particular case, I filed a motion for recusal. On the day I filed my motion for recusal, the trial judge came in and placed his Facebook page that was then public under seal and made a finding that there is a privacy right of all of the individuals that were his friends on Facebook. That was the first thing that happened on the day the motion was filed. We come back sometime later and we have a hearing on that particular motion. And when we come back for that hearing, I'd like to read some excerpts from what happened at the hearing. There are again 205 connections with the trial judge in Middle Tennessee State University and their athletic program. On page 30 of the brief, the court, sure, and this is the court addressing me, sure, and I respect your opinion, Mr. Brandon, and if you want to file an ethical complaint against me, you go ahead and do it. But here's the deal. To be quite honest, I didn't think my Facebook page was public. I thought, and maybe I'm not very good at this stuff, I thought it was private. And I thought you had hacked into my account or got somebody to pretend to be my friend and went through all of that stuff. But I'll check on that. But when I was looking at it, I thought, you know what? If Mr. Brandon doesn't like Mr. Mr. Ensel is the coach of the Blue Raiders, the women's basketball coach, the first witness in this case. You know what? If Mr. Brandon doesn't like Mr. Ensel to be one of my 1,500 friends, he's probably not going to like that, just not the District Attorney General's office, some of them, but also trial lawyers. And I thought, you know what? To be on the safe side, I'm going to go through. And I tried to. It took me about 2 days. I tried to remove all of those names, but let me tell you this, Mr. Brandon. You have a situation where the judge's Facebook page was made an exhibit to the motion for recusal. When we come to court and had a hearing on this, the judge had gone through and defriended a quantity of his friends. His page was set to private. There was no way to get back into that. There was no disclosure of who all he had defriended. He says he defriended members of the district attorney's office, Coach Ensel at MTSU, and he doesn't really get specific past that. And on that same date that we had this same hearing, page 31 of my brief, the court, wow, okay, 2 or 3 days ago, I contacted the legal department, not Coach Ensel. This is the trial court. He went and got an affidavit from the ladies' basketball coach the night before trial. Wow, okay, 2 or 3 days ago, I contacted the legal department, not Coach Ensel. I contacted the legal department of MTSU and I asked them. I sent them a copy of your motion to recuse and I asked them to contact Coach Ensel and do an affidavit for me saying anything about my relationship with him. On down the page, I'm attaching an exhibit, an affidavit. Okay, then it says no one named Don Ash is listed as one of my friends on the social networking site Facebook. That's right, because when he looked, I had taken his name off. This is the trial judge speaking. I had taken his name off. I took all the lawyers' names off. And I took off some other people, basically, that I wasn't sure who they were. So that's my fault too for not keeping up who my Facebook friends are. This is the trial on down, Mr. Brown, this is me. I said, Judge, I'd repeat my objection to hearsay. The court, great, exhibit number 2. Have you got any other proof that I'm connected to MTSU? Because the basketball coach says I'm not. Have you got anything else? Now, I argued in my brief that if you all would go, I think that motion to recuse was a 20-page, if you read the transcript, and the tone that was just inherent throughout this entire trial, that's an excerpt from it. The state argues in their responsive brief that I've talked about some law that came in after we had the trial in this case, or the motion to recuse. And that's Supreme Court Judicial Ethics Rule number 12.01. I argue that law applies, but even if you go back under the other law, you still have a situation where judges have a responsibility. It's not what is the least we can get by with. We're everywhere you look, anywhere in the states, and they differ on this. And this whole social media is really an issue that the ABA has taken a little bit of a position. Some states do this, some states don't. But you still have judges are not to be arbitrary, an appearance of impropriety. It's always about that. Always there is an undertone, an appearance of impropriety. The judicial ethics opinion I referred to requires disclosure. In this particular case, you have a judge delete his friends so that nobody can even get back to it. The judicial ethics opinion of October 2012 says and this is the issue, whether judges may utilize social media such as Facebook, and if so, the extent to which they may be able to participate. That opinion goes on to say if the trial court is going to participate in social media, they must do so with caution and with the expectation that their use of the media likely will be scrutinized by others. And then that same case calls for a balancing test. And the balancing, and I say case, that judicial ethics opinion, the balancing test is whether the benefit and the utility of participating in social media justify the attendant risk. The Florida Supreme Court judicial ethics opinion, which I attached as an exhibit to my motion to recuse, provides lawyers who may appear before the judge as friends, social media or Facebook friends, on a judge's social networking page reasonably conveys to others the impression that these lawyers' friends are in a special position to influence the judge. There again, there is a need for uniformity of decision. We argue in this particular case that Ms. Madden did not receive a fair trial. It flies directly in the face of a fair trial. We submit we do have the appearance of impropriety on that issue. I'll move on to my juror question issue. Juror questions is governed by Rule 24.1, and it provides that questions must be in writing, anonymous, and submitted at the end of a witness testimony. It says a little bit more than that, but those are the three basic issues. I was here before. I don't believe any of you gentlemen or ladies were here the day that I came down, but I argued State versus Reynolds in this court on juror question issue. And at that time, there was a lot of question from the judges regarding the anonymity. What does that mean? And did you have that in your case? And I didn't have it in that particular case. But in this case, we do. And anonymity is ambiguous. At the trial in this particular cause, when I filed my motion objecting to juror questions, the judge raised the issue of, I'm going to do it. This is kind of paraphrased. I'm going to do it, but do you all have any suggestions as to how we can address the anonymity? General Weitzel, and I put this in my brief, said, Judge, I suggest you have everybody write down, if they want to write have a good day or they just want to send in a blank piece of paper, something where all this paper is coming in at one time and then nobody has, it's kind of that's what you go with. Well, that wasn't the practice utilized in this particular case. The first time during the trial that there was an issue with respect to juror questions comes on page 34 of my brief. This is after the testimony of the judge's Facebook friend, Coach Rick Insel. The court, this is at the conclusion of his testimony, the court. Any questions from our jurors? And I had one submitted earlier, but it was not submitted correctly. You've got to give it to Ms. Kimbrough over here, so obviously I couldn't ask that. And the purpose of questioning really is not to develop theories of your own, but really to ask to kind of fill in the gaps if there's something like that. And I'm going to find that both of these questions are inappropriate, so I'm not going to ask either of them. But counsel, I will disclose to you those in a moment. Okay, right there, you've got the issue of 24.1. It says questions come at the end. Those are questions being passed down in the middle of the trial. That's going to the judge before the end. He's never asked for questions, or he asked for questions, but they've already started coming in. 24.1 says you address it with trial counsel, then you come back to the jury. Here, you have questions going on in the middle. You have the judge making a ruling before he ever consults counsel for either of the parties, and then the question gets turned over. Another witness, Detective Mongold, still on page 34. And there's confusion and commotion with how these questions are going to get asked. General Weitzel said, this is the district attorney, he says, Your Honor, I wonder if the jury might have a 5-minute break while the court, Mr. Brandon, and I discuss something. The court, sure. And let me say this. I know that I think one of the jurors passed a question to Miss Kimbrough. The way this works is we don't ask questions or don't write them down until after they've testified and they've been cross-examined. So we're going to wait. That's the way we do it. We wait until that time period. So Miss Kimbrough, whenever we go back out, and we'll take a 5-minute break, whenever we go back out, if you'll just give that note back to whichever juror passed it, and y'all can just hold on to it and give it to me at the conclusion of this person's testimony. At the conclusion of Detective Mongold, same witness, he's a detective with the Murfreesboro Police Department. At the conclusion of his testimony, so this is after these notes have gotten passed during the middle of his testimony, the court takes a break, come back in, he finishes testifying. We observe who's asking questions. It's juror number 5 on the front row. And because he's the only one that sends a piece of paper in. I said, Mr. Brandon, just one thing. I just wanted to put on the record, Mr. Weitzel, that's the district attorney, Mr. Weitzel and I both saw the 5th juror down from the left across on the front row be the one to submit that question. The court, well, what does that have to do with it? Mr. Brandon, I just wanted to put that on the record. The court, well, there was more than one. Does anybody know who else submitted one? Mr. Brandon. He would have been the only person to hand a question in. The court, there were 2 questions, though. So you didn't see who the second one was. Mr. Brandon, he was the only person we saw hand a piece of paper in. The court, okay, well, just for the record, there were 2 questions that were asked, so I don't know who the other juror was. All right, if you'll get the jury, please, everybody rise. Now, if you just think about, and one time I asked, I meant it as a rhetorical question, but I was down here arguing, and I asked a question, and one of the judges said, you can't ask us questions, so I'm not trying to ask you any questions. This is kind of food for thought is the way I pose this. But if we're sitting here right now and during the middle of me up here arguing, Judge Williams sends a note down to Judge McMullen. Okay, and during the course it passes through Judge Woodall's lap. Is there any way in the world you would even begin to say that you've known what I've been talking about if you're in the process of writing notes, handing notes, receiving notes? Well, the distinction in my analogy and what happened at the trial is I'm standing in front of 3 Court of Appeals judges making an argument. What I say is not proof. Where this happened was at the trial of Miss Madden on a first-degree murder case where you've got jurors passing questions during the middle of testimony. During the middle of testimony. It's not during the middle of a lawyer talking, it's during the middle of a trial. So how much do you think anybody's paying attention? And then anonymity. Okay, it's vague. What does that mean? We identified the juror. We identified the only juror we saw sending it down. The Rule 24.1 says that it's to go at the end of a witness testimony. This is going on during the middle of it. And so we just submit that that's a problem all of the way around. I also want to point out that there's another social media issue, and I say this because I've got it in my brief. I'm not asking you all to make a decision on this today. There was a lot of Twitter, and the Twitter that we have is Miss Stewart, the decedent, tweeting about Miss Madden right in the 10 minutes prior to her death. We entered an agreed stipulation of fact because if you read this transcript, the judge was not going to let any of that in. We entered an agreement just to be able to get it in and then so you all could say, well, Mr. Brandon, how is that relevant? You didn't submit it as an issue, and didn't you reach an agreement? And the issue is yes, but it goes to the recusal. This was such a hostile trial that had we not have agreed, nothing would have come in, and then you're in a spot where how do you play those cards? Where's your strategy at? Do you get in what you can get in and hope you can retrieve a not guilty verdict, or do you go with what's right and none of it comes in and try to win your case on appeal? And I tell people, don't ever come hire me thinking you're going to win on appeal. If you went and won in trial court, your odds go down substantially when it comes to the appellate court. And that's just, I think that's what, not the law says, but if you read the two, that's just the truth of how it all works out. And so under Ruan, State versus Ruan.
Mr. Brandon, I'm
up.
Interrupt you, but you're eating into your 5 minutes.
Okay. Okay. No, I appreciate the more. I was looking around for a clock. Like that first lawyer said, it's her first time and she's a little nervous. I don't think the nervous. I've been down here probably 15 times and I still get nervous when I come, so I'm with her on that. I'll close with this. According to the law, if the error affirmatively appears to involve a substantial right which would prejudice the judicial process, it results in reversal. Both the juror question and the recusal results in prejudicing the judicial process. Kind of like, I think it was Judge Cardozo, I remember this from contract law, you have a miscarriage of the judicial system. This case is a miscarriage of the judicial system. Thank you all.
Good morning, Your Honors. Michelle Consiglio-Young on behalf of the state. To address both of the issues the opposing counsel brought up this morning, first, as far as the friending issue on behalf of the trial judge, the state would submit that first, as far as the standard of review that this court must look at, it would be an abuse of discretion standard. We are not under plain error review here, as opposing counsel has said, because the issue was brought up, the pretrial motion was also brought up on the motion for new trial. So therefore, we're under the abuse of discretion standard that was in effect at the time of this trial. The new Supreme Court rules regarding judicial conduct, 10b, was put in effect after this trial. So, and that standard is de novo, which anything from here on out would be under that. But for this particular case and this particular issue, this court is looking at the trial court's decision to deny the motion to recuse under abuse of discretion standard. That's just the first thing I wanted to point out to this court. As far as the allegations made on appeal, it is true that the trial court had a Facebook page, was Facebook friends with Coach Rick Insel, who is the women's basketball coach of the MTSU women's basketball team, on which the victim played. However, there is no proof that was presented at trial, at the pretrial motions, at all, anything to prove beyond the fact that they were just Facebook friends. No connection, no anything that would say that they had any kind of material relationship, anything that would be relevant to the case, anything that would somewhat alter the trial judge's perception of the case, ability to preside over the case, the ability to be impartial in the case. Nothing was presented besides the mere fact that there was a Facebook friend connection in this case that would warrant recusal on behalf of the trial court. The opposing counsel alleged that because there was a Facebook friend issue, that therefore he could not preside over the trial, that the trial court had looked at Facebook comments posted on Facebook, which there is no proof whatsoever in the, I'm sorry, Your Honor.
I think what counsel is saying is that the trial court preempted him from presenting any of that proof by shutting down the Facebook page.
The trial court did not shut down his Facebook page. He did go in and remove friends from it. he made it very clear in the pretrial motion, in the pretrial motion hearing, and the order denying recusal is very detailed. The court went through every single step, really put out there and said, I don't have anything to hide. This is what, my personal page. I happen to be friends with some people. I live in Murfreesboro. I'm involved with the community. I'm going to know these people. As far as be aware of them in the community, not have, close connection with them. The trial court did say, because the opposing counsel and defendant seem to have a very large issue with me being connected on social media, I'm going to go ahead and take off anything and anybody. And this was not limited to just MTSU people. He took off DAs, other trial counsel, other judges, anybody for any case that it could seem to be some conflict. But not just because, okay, I need to hide that I'm friends with Rick Insel and this is going to cloud my judgment on this case. There was nothing of that sort, and the trial court made it very clear that there was nothing that he was trying to hide or be facetious or fix any kind of impropriety or ability to be impartial in the court. And there was never any part of that. He just made it very clear and put it just squarely out there for everyone in the courtroom to know that this is what I'm going to do in this case. In doing that, he went ahead and did get an affidavit. He did call the MTSU legal counsel just to get an affidavit from Coach Insel that they never had any connection. In that affidavit, they said there was no connection, that they've never spoken, that they've never had any kind of relationship. So the court just wanted to put that out there because he was being alleged that this being inappropriate. And it looked like, when you look through the trial transcript and everything, the court's trying to protect its integrity also, because it was being personally attacked on the level, saying that it could be impartial in ruling over the trial. So he did go ahead and take those precautions, which there's nothing that says that he couldn't do that. As far as any other proof, there was just nothing presented. So the court went ahead and looked at everything, considered the Code of Judicial Conduct, considered different opinions, different other cases, really considered the case before it and the specific witnesses that would come before it. I will say that it was not clear that he even knew that Coach Insel would be a witness in this case. This was a pretrial motion. It's not clear that there was a list of already the witnesses that went through or anything. I mean, this is all done before, very much before we went to trial. This is in December, I think, the pretrial hearing. The trial was actually in May of the next year. So, so without the Facebook connection on its own, without proof that there was bias or prejudice or anything that there would be a relevance to this case, would not amount to an abuse of discretion on behalf of the trial court. And I know that the opposing counsel cited ABA opinions and other judicial ethics opinions, and all of those are exactly that. They're opinions from the bar associations that say what they should do. But I will point out that none of those opinions say that a trial judge should be completely refrained from and being involved in any social media at all. So there's nothing that says that the judge, any trial court, should have no social media connection. And in this day and age, it's very hard. It's hard not to be connected online because there are so many different other groups and other connections and community connections that require involvement in social media. So it's nothing that says that. It's just you would have to avoid contact that would cause appearance of impropriety. And even if that objective standard caused an appearance of impropriety, any reasonable basis for that the trial judge could not preside impartially does still not apply here. There was no reasonable basis, especially because we didn't have any proof presented whatsoever that the court had any connection besides the mere fact that he was Facebook friends with Coach Insel. And I'm sure your honors are aware of Facebook and know how it works, but it's almost equivalent of maybe you know someone in the community, you see them while you're out to lunch, and you acknowledge them, maybe. It's really nothing beyond that. And there's nothing in our cases or anything that say that the court trial judges would not be allowed to do that. So based on that, without any other proof of bias or prejudice, the trial court did not abuse its discretion in denying the motion to recuse in this case. As far as the second issue of juror questions, first, the state would submit that the opposing counsel has waived this. Opposing counsel failed to cite anything in the record, failed to cite any specific instance of not allowing questions, identifying specific jurors, leaving the state in this court to have to go through the entire record and find exactly what he's talking about. Based on that, I would say it was waived, but if this court does go on and consider the issue, first, as far as the procedure is concerned, the trial court very, very meticulously went through the procedure. Before trial and the pre-trial jury instructions said that I'm going to allow juror questions after witnesses present their testimony. If you have a question, when it went ahead and said all that, the opposing counsel did not object at that time. However, after certain witnesses, when jurors did have questions, opposing counsel did object and did renew the objections every time there was a question after opposing counsel, after witness testified. But as far as the specific procedure, the trial court went ahead after I think there was only 2 instances where it didn't specifically ask if you had a question, if the jurors had a question, but I'll get to that in a moment. But as far as the procedure, the trial court asked if the witnesses had questions, pass it to the clerk, and then the clerk would gather whatever questions, bring it over to the trial judge. The trial judge would review them, call a bench conference, have both parties come up, review it, discuss whether or not those questions would be valid as far as comply with the rules of evidence, would be relevant, and etc. And then once the trial court determined that they were appropriate, he would ask the question to the witness. In this case, with a very long trial, lots of witnesses, there were 7 questions submitted. There were 3 that were asked and 4 that weren't, showing that the court really did go through and meticulously follow the procedure, decide whether or not the questions were valid, and proceed appropriately. The opposing counsel alleges that the trial court identified jurors on the record, and that is just blatantly wrong when you look at the record. The trial court never one time said, okay, juror number 5, juror number 1, I saw you do this. Any mention of a specific juror was made by opposing counsel, and that's it. And even when opposing counsel said, juror 5 asked a question that trial court, you can see plainly through the records that I don't know, I don't know, is that okay? That's fine. This is not right time. That's a question anyway.
Are we going to be able to tell this in the record?
Yes.
Saying what in reference to what juror is doing what?
The only thing you can tell in the record is when opposing counsel says, okay, Your Honor, we saw juror 5 send in a question, and you'll see that the trial court says, okay, I didn't, that either 2 questions, I don't know, this is not appropriate time anyway, we'll take that later. There's no, explicit, they asked a question, they're not allowed to. There's nothing like that. It's more just the, typical trial procedure, and things go on in trial, and you're just like, okay, let's handle that. We'll deal with that. That's not appropriate time. We'll deal with that later. But there's nothing specifically in the record that says, okay, here, the trial court said, no, you can't ask this, or a trial court specifically identified a juror on the record. There's nothing in there that, and once you look through the record, I think that'll be clear to your honors once you consider the record. And as far as questioning the witnesses, as I said, I would get back to the witnesses. The trial court did ask after every witness whether the jury had questions. He only didn't ask after 2. One came back as a rebuttal witness, and trial court did ask at that point if any of the jurors had questions. And then there was a detective that he didn't ask, but it just seemed like, you get caught up in trial and you didn't ask. So But that's completely different from saying you prohibited questions. Just because a trial court didn't specifically ask if the judges had questions doesn't mean that he prevented or prohibited questions from being asked. And it was made very clear throughout the entire trial that they were welcome to ask questions, and that was a procedure in this trial. So therefore, there's nothing in any of the procedure that went wrong that the trial court abused or anything in this case. And the trial court, therefore, didn't abuse its discretion in any part of the asking questions portion of the case. As far as the constitutionality, the Tennessee Supreme Court in James has confirmed that this is a constitutional practice because it's codified in the Rules of Criminal Procedure 24.1c. It just said very plainly, it used to be a perilous practice that we should avoid scrupulously, but now that it's been codified since 2003 in our own procedural rules that have been approved, it is not unconstitutional. It's not a due process right violation. There's no unfairness to impartial jury or anything like that. There's no constitutional question. And this court addressed that also, as opposing counsel stated in Reynolds. This court confirmed that the jury question issue is constitutional. As far as the Twitter question issue that was raised by opposing counsel, the state would submit that's waived. There was no issue of that brought up at all on appeal. Nonetheless, it was all it was pertinent to stipulation at the trial. Any argument on that is just not before this court at this time. As far as the other two issues of sufficiency and proper sentence, sufficiency, the state would submit that the opposing counsel has waived that argument here. I know that this court does not usually see that sufficiency issues are waived, but there is a total of about 2 sentences in that entire brief on this entire large case that just mention the buzzword of sufficiency. There's no actual argument, and that is frankly unacceptable in a case of this magnitude. But as far as the sentence, and if you do consider sufficiency, the state would rely on its brief for questions or issues that this court would have. And if this court has no further questions, the state will ask that you affirm the judgment on appeal.
Mr. Brandon, you've got about 4 minutes left.
Yes, sir. Briefly, on the issue of juror questions, and did I object, I'd like to quote y'all from page 18 of my brief. The judge is going through a juror question. Mr. Brandon, just other than the objection I've already stated, the court, I got that the first 20 times, so I got that. He doesn't have to say it every time. I'll put it on the record that Mr. Brandon objects to every single question asked by every juror in every situation. So we got it, okay? It's a trial court. Now, I'm not sure what I'm supposed to do as a trial lawyer. This last lawyer, it was not my opposing counsel today, but in that first case, she got up here and told y'all something that she said it may not appear from the record. So I'm going to do the same thing, and if I'm doing something I'm not supposed to, you disregard it. I took a lawyer with me the day I had the motion to recuse. I had a lawyer there for me. I thought the judge was going to put me in jail that day. I went through an issue with him over this deal with arraignment because this case is unconventional all the way through. We get to arraignment, and the trial judge sets a trial date under Rutherford County local rules, and it may be an unwritten rule. I couldn't find it written, but they say it all the time. When you set a case for trial, you will only plead as charged. No negotiations will be accepted. That's a rule that we function under in Rutherford County. I got set for trial on my arraignment date. It was clear this case was destined to be tried by Judge Ash from the beginning. Whatever his reasons were, it was clear. I objected to juror questions every time I had a chance. And if I'm not objecting enough, I once again point y'all to page 18. And as far as Coach Endell being a witness, she said nobody knew about that. I don't agree with that. Go back and look at the record. When this case first got set for trial, you'll notice that that's not when the trial went down. The state filed a motion, and the reason for the state's motion was Coach Endell wasn't going to be available. It was no mystery that Coach Endell, why do you think he goes and gets an affidavit from Coach Endell? My motion to recuse didn't just address Coach Endell. It was pages and had an exhibit attached for every one of the reasons. The pictures of MTSU in the jury room, just all of the connections with this judge in MTSU. It's just Coach Enzel is when you've got 20 minutes to argue and you've got a brief and you continue to neck down what went on over the case since March the 2nd of 2011, you only have time to advance certain things while you're up here talking. So I encourage you to look at the transcript on that issue. And this is how I'll close. My opposing counsel says, well, judges, y'all know this Facebook thing, and it's just the equivalent of acknowledging an acquaintance at lunch. Well, if it's the equivalent of acknowledging an acquaintance at lunch, then why in the world do you go back and you start defriending and deleting all of those people when it comes time to try the case? I submit there's only one conclusion you could draw, but whatever template you want to stick on this case just don't fit within it. And we're asking for a new trial. Thank you all very much.
Does that conclude today, this morning's docket?
Yes, Your Honor, this one.
We'll be in recess till 1:30.
All rise. This court stands in recess